I came home from a business trip to Phoenix to find 12 toddlers running around my living room in Scottsdale, Arizona. And a woman I had never seen before charging parents $40 per child for what appeared to be a fully operational daycare center in my house. My name is Zachary Quinn, and I had been gone for 5 days visiting potential clients for my software consulting business. When I pulled into my driveway that Wednesday afternoon, the first thing I noticed was the collection of minivans and SUVs parked along the street in front of my house. Our HOA had strict parking rules, so seeing this many vehicles clustered in one spot was unusual. I grabbed my suitcase from the trunk and walked up to my front door, keys in hand, completely unprepared for what I was about to discover. The sound hit me first. As soon as I opened the door, I heard children laughing, crying, and screaming in that particular chaotic symphony that only a group of young kids can create. I stood frozen in my entryway, my brain struggling to process what my eyes were showing me. My furniture had been rearranged. My coffee table was gone, replaced by colorful foam mats. There were toys everywhere, plastic bins lining the walls, and a changing station set up in the corner where my bookshelf used to be. A woman in her mid-40s with a blonde bob haircut and a vest covered in cartoon animals turned to look at me. She had that particular expression of someone who believed they were completely in the right, no matter what evidence suggested otherwise. "Excuse me, you cannot just walk in here," she said, her voice sharp with authority. I blinked at her. "This is my house." Her face went through several expressions in rapid succession: confusion, disbelief, and then something that looked almost like defiance. "No, this is the community daycare facility. I have all the proper permits and approvals from the HOA. The HOA does not have the authority to turn my private residence into a daycare," I said, my voice rising. "Who are you, and why are there children in my home?" Before she could answer, another woman appeared from what I assumed was my kitchen, holding a tray of apple slices. "Brenda, do we need more snacks?" "Oh," she stopped when she saw me, her eyes going wide. "Everyone needs to leave," I said, trying to keep my voice calm despite the rage building in my chest. "Right now. This is my private property, and I did not authorize any of this." The woman who had been called Brenda pulled out her phone with a flourish. "I am calling the HOA president." "You are disrupting a licensed childcare operation." "Call whoever you want," I said, "but these children and all of you need to leave my house immediately, or I am calling the police." The next 20 minutes were absolute chaos. Parents started arriving for pickup, confused about why I was there, and insisting they had paid for a full day of care. Brenda, whose full name I learned was Brenda Morrison, kept waving a folder of paperwork at me, claiming she had every right to be there. I stood my ground, took photos of everything with my phone, and watched as the last child was finally picked up. Once the children were gone, Brenda refused to leave. She sat on my couch, the one she had pushed against the wall with her arms crossed. "The HOA is sending someone over to sort this out. You are making a huge mistake." "The only mistake here is yours," I said. "You broke into my home and started a business without my permission. That is illegal on about 15 different levels." "I did not break in," she snapped. "I was given a key by the HOA. This property was listed as vacant and available for community use." My blood ran cold. "Who told you this house was vacant?" Patricia Schneider, the HOA president. She said the owner had moved and the property was being transferred to HOA management for community purposes. I pulled out my phone and called my real estate attorney, David Chen, who I had worked with when I bought the house 2 years ago. While it rang, I stared at Brenda. "I never moved. I have been living here continuously since I bought this property." Someone has committed fraud, and you are going to be held responsible for every day you have operated this daycare without my consent." David answered, and I explained the situation as quickly as I could. He told me to document everything, not let Brenda take anything from the house, and that he would start drafting legal documents immediately. He also suggested I call the police to file a report, which I did as soon as I hung up with him. The doorbell rang, and I opened it to find Patricia Schneider, our HOA president, standing there with that same self-righteous expression I had seen on Brenda's face. Patricia was in her early 50s, with gray streaked dark hair pulled back in a tight bun, and the kind of rigid posture that suggested she had never relaxed in her entire life. "Mr. Quinn," she said, her tone suggesting I was a child being called to the principal's office. "I understand there has been some confusion." "There is no confusion," I said. "You gave someone access to my private property and told them they could run a business out of it. That is illegal." Patricia stepped inside without being invited, her eyes scanning the transformed living room. "The HOA board voted to establish a community daycare facility. Your property was selected as the most suitable location due to its size and layout. We sent you multiple notices about this decision." "I never received any notices because you never sent them," I said. "And even if you had, the HOA does not have the authority to seize private property for community use. That is not how property rights work in America. According to the HOA bylaws, Section 12, Paragraph 4, the board has the right to utilize vacant or abandoned properties for community benefit until such time as the owner returns or the property is sold." I pulled up my HOA bylaws on my phone, something I had downloaded when I first moved in. Section 12, Paragraph 4 says that the HOA can maintain landscaping and exterior appearance of properties that appear abandoned after attempting to contact the owner for 30 days. It says nothing about entering the property or using it for any purpose, and this house was never abandoned. I live here. I pay my HOA dues. I have been receiving and paying my utility bills. My mail is delivered here daily. Patricia's jaw tightened. "We attempted to contact you multiple times." "Show me proof. Show me the certified letters, the emails, the phone records. I want to see every attempt you made to contact me." She could not, of course, because no such attempts had been made. The police arrived 15 minutes later, and I filed a report for trespassing and illegal entry. The officers took statements from both Brenda and Patricia, examined the paperwork. Brenda kept insisting proved she had the right to be there, and ultimately told both women they needed to vacate the property immediately. "But what about my business?" Brenda protested. "I have contracts with parents. I have children enrolled." "That is not our concern, madam," one of the officers said. "You are operating a business in someone else's home without their permission. You need to leave now, and you need to remove all of your property." It took another 3 hours for Brenda and her assistant to remove all the daycare equipment from my house. I documented everything, taking photos and videos of every item as it was carried out. I also took detailed notes about the state of my home, including the scratches on my hardwood floors from furniture being moved, the crayon marks on my walls, and the mysterious sticky substance that covered most of my kitchen counter. After everyone left, I stood in my ransacked living room and tried to process what had just happened. Someone had entered my home without permission, moved my belongings, and run a business for what appeared to be at least several weeks based on the wear and tear I was seeing. The financial implications alone were staggering. If Brenda had been charging $40 per child and had 12 children per day, that was $480 daily. If she had been operating for even a month, That was over $14,000 in revenue generated from my property without my consent or compensation. I called David back and gave him the update. He listened carefully, asked detailed questions about what the police had said and what paperwork Patricia and Brenda had shown, and then told me we had an excellent case for multiple lawsuits. We are going after both Brenda Morrison personally and the HOA as an organization, David said. Brenda for trespassing, illegal business operation, and conversion of property. The HOA for fraud, breach of fiduciary duty, and violations of your property rights. We are also going to file complaints with the state licensing board because I guarantee Brenda did not have proper licensing to operate a daycare, and if she did, it would not be valid for your address since you never consented. How long is this going to take? I asked. Depends on how reasonable they want to be, David said. But based on what you have told me, I do not think reasonable is in their vocabulary. Plan for this to take several months at minimum. In the meantime, I want you to get estimates for repairs to your home, change your locks immediately, and consider installing security cameras. I would not put it past these people to try something else. I followed his advice. That night, I had a locksmith come out and change every lock on my house. The next morning, I had a security company install cameras covering every entrance and the interior of my home. I also contacted several contractors to get estimates for repairing the damage to my floors and walls. The first estimate came in at $3,200. The second was $2,800. I went with a third contractor who quoted $2,600 and could start immediately. While the repairs were being done, I started digging into exactly how long Brenda had been operating her illegal daycare. My neighbor across the street, an elderly man named George who spent most of his day sitting on his front porch, was happy to talk. "Oh, that daycare has been running for about 3 months now," he told me. "Started right after Labor Day. I thought it was strange, but Patricia came around and told everyone in the neighborhood that you had agreed to it as a community service. Said you were some kind of philanthropist." 3 months. 90 days of operation at $480 per day meant Brenda had generated over $43,000 in revenue from my property. The rage I felt was almost overwhelming. I filed complaints with the Arizona Department of Health Services, which oversaw daycare licensing, and with the Scottsdale City Business Licensing Office. Within a week, I received confirmation that Brenda Morrison had never applied for or received a license to operate a daycare at any location, let alone my address. This meant she had been operating an illegal, unlicensed childcare facility, which opened up even more legal liability. David filed the lawsuits 2 weeks after the initial incident. We sued Brenda Morrison personally for trespassing, conversion of property, unjust enrichment, and negligence. We sued the HOA for fraud, breach of fiduciary duty, negligence, and violations of my property rights under both state law and the HOA's own governing documents. We asked for actual damages, punitive damages, attorney's fees, and a court order barring both Brenda and the HOA from ever entering my property again. The response from the HOA was exactly what I expected. Patricia sent a letter through their attorney claiming that I was harassing HOA leadership and threatening to fine me for violating community harmony standards. David sent back a letter explaining that truth was an absolute defense to harassment claims and that any attempt to fine me would be added to our lawsuit as retaliation. Brenda's response was more interesting. Her attorney claimed that she had acted in good faith reliance on the HOA's representations, and that any damages should be sought from the HOA. not from her personally. This was a smart legal strategy, trying to shift all the blame to Patricia and the HOA board, but it did not absolve her of running an unlicensed daycare or refusing to leave when I told her it was my property. The discovery phase of the lawsuit was enlightening. We subpoenaed Brenda's financial records and found that she had been operating the daycare for actually 4 months, not 3. She had been very careful about hiding the income, depositing cash from parents into a personal account rather than a business account, and not reporting any of it on her taxes. The total revenue was over $57,000. We also discovered through HOA records that Patricia had been planning to start a community daycare for over a year. She had approached multiple HOA members about volunteering their homes, and everyone had declined. My name appeared in meeting minutes from a board meeting I had never been notified about, where Patricia claimed I had volunteered my home while I was traveling. This was a complete fabrication, but it gave her the cover she needed to convince Brenda and the other board members that everything was legitimate. The most damning evidence came from Patricia's emails. She had written to another board member saying that my house was perfect because I traveled frequently for work and would not notice until the daycare was well established and generating community goodwill. She explicitly stated that she planned to present me with a fait accompli and pressure me into allowing it to continue by making me look like the bad guy for shutting down a childcare service that working parents depended on. When David showed me these emails, I felt vindicated but also deeply disturbed. This had not been a mistake or a misunderstanding. It had been a calculated plan to steal my property for Patricia's pet project. The HOA tried to settle early, offering to pay for the repairs to my home and agreeing not to fine me for anything related to the incident. David laughed when he read their offer. "They are lowballing you because they know they are in serious trouble," he said. "We have them dead to rights on fraud and conversion. We are going to trial." Brenda also tried to settle, offering $10,000 and an apology. David countered with a demand for the full $57,000 in revenue plus damages, attorney's fees, and a public apology. She refused. The case went to trial 8 months after the initial incident. Those 8 months were not pleasant. Patricia launched a campaign within the HOA to paint me as a troublemaker and a liar. She sent letters to all the homeowners claiming I was suing the HOA frivolously and that everyone's dues would have to be increased to cover legal costs. Several of my neighbors stopped talking to me. Someone egged my house twice. My car was keyed in my driveway. I documented all of it and added harassment and intentional infliction of emotional distress claims to the lawsuit. David also filed for a restraining order against Patricia personally after she showed up at my house at 10 o'clock at night demanding I drop the lawsuit. The judge granted a temporary restraining order and scheduled a hearing. At the restraining order hearing, Patricia showed up with 3 other HOA board members as character witnesses. They all testified about what a dedicated community servant she was and how I was being unreasonable. Then David played the security camera footage of Patricia pounding on my door at night, yelling threats about making my life miserable if I did not drop the lawsuit, and refusing to leave until I threatened to call the police. The judge granted a 1-year restraining order on the spot and made it clear she was not impressed with Patricia's behavior. "Miss Schneider, you are the president of a homeowners association, not a mob boss," the judge said. "You do not get to intimidate people into dropping legitimate legal claims. If I hear of any further harassment of Mr. Quinn, I will hold you in contempt." The main trial started on a Monday morning in April. The courthouse in downtown Phoenix was busy, and we had been assigned to a judge with a reputation for no-nonsense efficiency. David had prepared me extensively, running through likely questions and making sure I understood how to present myself as a credible, sympathetic plaintiff. The first day was mostly jury selection and opening statements. David laid out our case clearly. I had gone on a business trip and returned to find my home had been illegally converted into a daycare without my knowledge or consent. The HOA president had orchestrated this through fraud and deception, and Brenda Morrison had operated an unlicensed business that generated substantial revenue while causing damage to my property and violating my fundamental rights as a homeowner. The defense attorneys for both the HOA and Brenda tried to frame this as a misunderstanding that had been blown out of proportion. They claimed that everyone had acted in good faith and that I was seeking an unreasonable windfall from an honest mistake. The second day, I testified. David walked me through the timeline from my business trip to my shocking discovery upon returning home. I described the condition of my house, the confrontation with Brenda, and Patricia's insistence that the HOA had the right to use my property. I kept my emotions in check and stuck to the facts, exactly as David had coached me. The cross-examination was aggressive. The HOA's attorney tried to suggest I had somehow given implied consent by traveling frequently and not being home. "Is it not true that you are often away from your residence for extended periods?" he asked. "I travel for business, yes, but that does not mean I have abandoned my home or given anyone permission to enter it," I replied. "But you never explicitly told the HOA not to use your home for community purposes." "I should not have to tell people not to break into my house," I said, letting some frustration creep into my voice. "That is a given in any civilized society." Brenda's attorney tried a different approach, suggesting I was exaggerating the damages and that the minor wear and tear was normal for any home. David countered this by introducing the contractor estimates, photos of the damage and testimony from the contractors themselves about what had caused the issues. The third day brought Brenda to the stand. She was nervous, fidgeting with her hands and avoiding eye contact. Her attorney led her through her version of events, painting her as a well-meaning child care provider who had been deceived by the HOA. "Did you know that Mr. Quinn had not given permission for you to use his home?" her attorney asked. "No, I had no idea," Brenda said. "Patricia showed me paperwork that said the house was available for community use. She gave me a key and told me everything had been approved." "What did you do when Mr. Quinn arrived and said you did not have permission?" "I was shocked," Brenda said. "I called Patricia right away because I thought there must have been some mistake." David's cross-examination was devastating. He pulled out Brenda's financial records and walked her through the revenue she had generated. "You made over $57,000 operating this daycare, correct?" Yes, but I had expenses," Brenda stammered. "You did not report any of this income on your taxes, did you?" "I was planning to. That is a yes or no question, Miss Morrison. Did you report this income?" "No." "You also never applied for a license to operate a daycare, correct?" Patricia said the HOA approval was sufficient. "Did you verify that with the state licensing board?" "No." "So you operated an illegal, unlicensed daycare in someone else's home without their permission, made nearly $60,000, did not pay taxes on it, and expected to face no consequences." "Objection," Brenda's attorney said, but the damage was done. Patricia's testimony on the fourth day was the centerpiece of the trial. She took the stand wearing a conservative navy suit and an expression that suggested she was being martyred for a righteous cause. The HOA's attorney tried to rehabilitate her reputation by focusing on her years of community service and her genuine belief that she was acting within her authority. Miss Schneider, why did you believe the HOA had the right to use Mr. Quinn's property for a daycare? Her attorney asked. The bylaws allow for community use of resources, Patricia said. I interpreted that to include properties that were not actively being occupied. Did you believe Mr. Quinn's home was abandoned? He was never there, Patricia said. His house was empty most of the time. I thought he had moved and was renting it out, or had simply left it vacant. David destroyed this narrative in cross-examination. He introduced evidence showing that I had paid my HOA dues on time every month, that my utilities showed continuous usage, that my mail was being delivered and collected, and that I had attended an HOA meeting just 6 weeks before Patricia claimed my house was abandoned. You were at the same meeting as Mr. Quinn in early August, were you not? David asked. I think so, yes. So you knew he lived in that house and was an active member of the community. He was not there often. But he was there sometimes, which means the house was not abandoned, correct, I suppose. And you never once tried to contact him directly about using his property, did you? We sent notices. Show me one piece of evidence that you sent Mr. Quinn a notice about this daycare plan. Patricia could not. David introduced phone records, email logs, and postal records showing that no one from the HOA had ever attempted to contact me about the daycare. He then showed the jury the emails where Patricia had explicitly discussed using my absence to establish the daycare without my knowledge. Miss Schneider, you wrote in this email that Mr. Quinn's house was perfect because he would not notice until it was too late. What did you mean by that? Patricia's face flushed. I meant that by the time he found out, the daycare would be providing such a valuable service that he would agree to let it continue. So you intentionally did not tell him because you knew he would say no. I thought he would be unreasonable about it. Or perhaps he would exercise his legal right to control his own property. Objection. The HOA attorney shouted, but the jury had heard enough. The rest of the trial focused on damages. David brought in expert witnesses to testify about the rental value of my property, the market rate for commercial childcare space, and the extent of the damage to my home. He also introduced evidence of the harassment I had suffered, including the security camera footage of Patricia's late-night visit and photos of my vandalized property. The defense tried to minimize everything, but their arguments fell flat. The jury deliberated for less than 4 hours. When they returned, the verdict was overwhelmingly in my favor. They awarded me $57,000 in actual damages from Brenda, representing every penny she had made from the illegal daycare. They awarded me another $15,000 in damages from the HOA for the harassment, property damage, and stress I had endured. They also awarded punitive damages of $75,000 from Brenda and $100,000 from the HOA, finding that both had acted with fraud and malice. The total judgment was over $247,000, plus attorney's fees and costs. I sat in the courtroom, stunned by the magnitude of the verdict. David was grinning beside me, shaking my hand and congratulating me on the win. Across the aisle, Brenda was crying, and Patricia looked like she had been struck by lightning. The judge thanked the jury and then turned to address the courtroom. I want to be clear that this verdict reflects the seriousness with which our legal system treats property rights. No one, not a neighbor, not a community organization, not even a well-meaning HOA president, has the right to seize private property for their own purposes. Miss Morrison, Miss Schneider, your actions were not only illegal but deeply troubling. You violated Mr. Quinn's trust, his property rights, and the basic social contract that allows communities to function. After the verdict, David filed the judgment with the court, and we began the process of collecting. Brenda filed for bankruptcy within 2 weeks, which complicated things but did not eliminate her debt. Bankruptcy courts generally do not discharge debts incurred through fraud, and our judgment clearly fell into that category. The HOA tried to appeal, but their attorney advised them it would be pointless given the strength of our evidence and the jury's unequivocal verdict. The real satisfaction came when the Arizona Department of Revenue and the IRS both opened investigations into Brenda for tax evasion. Operating an unlicensed business and failing to report nearly $60,000 in income had caught their attention. 6 months after the trial, Brenda was charged with multiple counts of tax fraud. She eventually pleaded guilty and was sentenced to 18 months in federal prison and ordered to pay back taxes, penalties, and interest totaling over $80,000. Patricia faced consequences too, though not criminal ones. The HOA board held an emergency election and removed her as president. Several homeowners filed complaints with the Arizona Corporation Commission, which oversees HOAs in the state, alleging mismanagement and abuse of authority. The commission launched an investigation and ultimately fined the HOA $25,000 for violating state regulations regarding proper notice, meeting procedures, and fiduciary responsibilities. Patricia tried to rally support and position herself as a victim of my vindictiveness, but too many homeowners had seen the evidence and heard the verdict. She became a pariah in the community and eventually moved away about a year after the trial. Collecting the judgment took time. The HOA had to take out a loan to pay my portion, which did indeed result in increased dues for everyone. But this time, the homeowners understood why and who was really to blame. Brenda's bankruptcy proceedings dragged on for months, but I eventually received a significant portion of what she owed through the sale of her assets, and a payment plan that would continue for years. I used some of the money to upgrade my home security system and to completely renovate my living room and kitchen, erasing any trace of the illegal daycare. I also set aside a substantial amount for what I called my HOA Defense Fund, money specifically earmarked for legal fees in case Patricia's successor tried anything similar. But the new HOA board was nothing like Patricia's regime. They were careful, respectful, and actually followed the governing documents. The new president, a retired lawyer named Michael, reached out to me personally to apologize for what had happened and to assure me it would never occur again. He also proposed amendments to the HOA bylaws to explicitly prohibit what Patricia had done and to create better oversight mechanisms for the board. I worked with Michael and David to draft those amendments, and they passed with near unanimous support from the homeowners. The new rules required board meetings to have proper notice, limited the board's authority over private property, created a dispute resolution process, and established term limits for board members. Life slowly returned to normal. My neighbors who had shunned me during the lawsuit gradually came around, some apologizing directly for believing Patricia's lies. George across the street became a good friend, and we often sat on his porch in the evenings, talking about everything from politics to sports to the latest HOA gossip. The daycare parents were an interesting aftermath. Several of them reached out to me, some angry that I had shut down their childcare solution, others apologetic once they learned the full story. One parent, a woman named Jennifer, was particularly persistent. She showed up at my door about 3 months after the trial with a homemade apple pie and a long apology. "I had no idea Brenda did not have your permission," she said. "She told us you were her landlord and had specifically set up the space for a daycare. We all thought it was this wonderful community arrangement. When you shut it down, I was furious. I thought you were just some greedy landlord who did not care about working parents." "What changed your mind?" I asked. "I actually read the news coverage of the trial," Jennifer said. "Before that, I was just going off what Brenda and Patricia were saying. But when I saw the evidence, the emails, the financial records, everything, I felt sick. We were all complicit in what happened to you, even if we did not know it." I accepted her apology and the pie, which was excellent. Jennifer and I did not become close friends, but we developed a cordial relationship, and she became one of the more vocal advocates for HOA reform in the neighborhood. The story made local news and even got picked up by a few national outlets. I did a couple of interviews, careful to stick to the facts and not embellish. The response was overwhelmingly supportive. People were outraged by what Patricia and Brenda had done, and my case became something of a rallying point for property rights advocates and HOA reform groups. I was invited to speak at a conference about HOA governance and abuse, which was surreal. Standing in front of 200 people at a hotel in downtown Phoenix, telling my story and answering questions about how to protect yourself from bad HOA boards was not something I ever imagined doing. But it felt good to turn my awful experience into something potentially helpful for others. One question from the audience stuck with me. A woman raised her hand and asked, "Do you regret buying a home in an HOA?" I thought about it for a moment. "Yes and no," I said. What happened to me could theoretically happen in any community if you have the wrong people in positions of authority. HOAs are not inherently bad, but they are governed by human beings, and human beings can be corrupt, power-hungry, or just incompetent. The lesson is not to avoid HOAs entirely, but to be vigilant, to read your governing documents, to attend meetings, and to hold your board accountable. And if your board does violate your rights, do not be afraid to fight back. The answer got applause, which was gratifying. As I approached the 2-year anniversary of the initial incident, I found myself reflecting on everything that had happened. The lawsuit had been expensive, stressful, and time-consuming. It had damaged relationships, caused me countless sleepless nights, and turned my life upside down for over a year. But I had won. More importantly, I had stood up for my rights and held people accountable for their actions. The money from the judgment was significant, but it was not really about the money. It was about the principle. Patricia and Brenda had thought they could get away with stealing my property for their own purposes because they believed I would not fight back. They had counted on me being too busy, too conflict-averse, or too intimidated by the HOA's authority to challenge them. They were wrong. I thought about all the people who probably would not have fought back, who would have been bullied or pressured into accepting the situation. I thought about how many other Patricias were out there in HOAs across the country, abusing their small amount of power and making people's lives miserable. And I felt satisfied that, in my own small way, I had pushed back against that. David remained my attorney and became a friend. We had drinks occasionally, and he loved telling the story of the case to other lawyers. "It is the most clear-cut conversion case I have ever seen," he would say. "Usually, there is some ambiguity, some gray area, but this was black and white. They took his house and used it for their own business." The audacity was breathtaking. I stayed in my house in Scottsdale. Some people asked if I would sell and move after everything that had happened, but I refused. Why should I give up my home because of what someone else did? The house was mine, paid for with my own money and maintained with my own effort. I had fought for it, and I was not going anywhere. The security cameras remained, and I checked them regularly, perhaps more than was strictly necessary. But they gave me peace of mind. I also made sure to notify the HOA whenever I traveled, not because I had to, but because I wanted there to be a clear record that I was actively managing my property and had not abandoned it. The HOA itself improved dramatically under the new leadership. They organized actual community events, like neighborhood barbecues and holiday parties, that brought people together instead of driving them apart. They maintained the common areas properly, enforced reasonable rules consistently, and communicated clearly with homeowners. It was what an HOA was supposed to be. I even joined the Architectural Review Committee, which was ironic given that I had spent a year suing the HOA. But I wanted to be part of making sure the organization functioned properly. Michael, the new president, was thrilled to have me. "Having someone with your experience and perspective is invaluable," he said. "You understand what can go wrong, and you will make sure we do not make the same mistakes." On the committee, I reviewed applications for home modifications, paint colors, landscaping changes, and other alterations that required HOA approval. I made sure we followed the rules, treated everyone fairly, and responded promptly to requests. It was tedious work, but it mattered. Every time we approved a reasonable request, or worked with a homeowner to find a solution that met both their needs and the community standards, I felt like we were demonstrating how the system was supposed to work. The case also had ripple effects beyond my immediate community. The Arizona legislature passed a law, nicknamed the Quinn Law in news coverage, though that was not its official name, that strengthened protections for homeowners against HOA overreach. The law clarified that HOAs could not claim abandoned properties without going through proper legal channels, required detailed notice procedures before any board action affecting individual properties, and created stronger penalties for HOA board members who acted fraudulently. I was invited to the bill signing ceremony at the state capitol in Phoenix. Standing there with legislators, other homeowners who had their own HOA horror stories, and advocates for property rights, I felt a sense of accomplishment that went beyond my individual case. We had actually changed the law. We had made it harder for future patricias to abuse their power. The governor shook my hand and thanked me for my courage in fighting back. "Property rights are fundamental to our society," she said. "What happened to you was outrageous, and I am glad we can do something to prevent it from happening to others." Brenda served her prison sentence and was released after 14 months for good behavior. I heard through the grapevine that she moved to New Mexico to live with relatives and was working as a grocery store cashier. I felt no particular satisfaction or sympathy. She had made her choices and faced the consequences. That was justice. Patricia disappeared from public view entirely. Someone told me she was living in Tucson, but I never confirmed it and did not particularly care. She was no longer my problem. As for me, my consulting business thrived. If anything, the publicity from the case brought me more clients. People who valued someone who stood up for themselves and fought back against injustice wanted to work with me. I hired 2 employees and expanded my services. The business I had been trying to grow for years suddenly took off. I also started dating someone, a woman named Natasha Sullivan who worked as an architect in Phoenix. We met at a mutual friend's party and she already knew my story. "You are the HOA guy," she said when we were introduced. I laughed. "That is going to be on my tombstone, is it not? Here lies Zachary Quinn, the HOA guy." "There are worse legacies," she said. You stood up for yourself and helped change a broken system. That is pretty admirable. Natasha and I took things slowly, both of us having been burned in past relationships. But we found we had a lot in common beyond our professional lives. She was thoughtful, principled, and had her own story of fighting against injustice in her field. We balanced each other well. When I finally introduced her to my house, I was nervous. The place still carried the weight of everything that had happened, even though it had been completely renovated. But Natasha walked through, admired the updates I had made, and said, "This is a great house. I can see why you fought so hard for it." That simple statement meant more to me than she probably realized. The house was not just a building or an investment. It was my home, my space, my piece of the world. Fighting for it had been about more than legal principles or money. It had been about refusing to let someone take what was mine. 3 years after the initial incident, I was living a good life. The judgment had been paid in full through a combination of Brenda's payment plan, the HOA's settlement, and asset liquidation. I had recovered every penny Brenda made from the illegal daycare, plus damages, plus attorney's fees. The total came to just over $290,000 after all was said and done. I used the money wisely. Some went into retirement savings, some went into my business, some went into home improvements and upgrades, and some went into a legal defense fund that I hoped I would never need to use again, but felt better having available. The HOA continued to function smoothly under Michael's leadership, and then under his successor, a woman named Linda who was equally competent and respectful. The neighborhood became a genuinely nice place to live, with friendly neighbors, well-maintained common areas, and none of the drama that had characterized Patricia's reign. I stayed active in HOA affairs, attending meetings regularly and serving on various committees. Other homeowners occasionally thanked me for what I had done, recognizing that my lawsuit had forced changes that benefited everyone. The culture had shifted from one of fear and compliance to one of participation and mutual respect. Looking back on the entire experience, from that shocking moment when I walked into my house and found it full of toddlers to the final payment of the judgment, I realized I had learned some important lessons. I learned that standing up for yourself matters, even when it is difficult and expensive. I learned that systems of power, even small ones like HOA boards, need oversight and accountability. I learned that most people are fundamentally decent, but that the few who are not can cause enormous damage if left unchecked. I also learned that justice, while slow and imperfect, can still work if you are willing to fight for it. There were moments during the lawsuit when I wanted to give up, when the stress and cost seemed overwhelming, when settling for pennies on the dollar seemed like the easier path. But I stuck with it, trusted my attorney, and let the legal system work. And in the end, I won not just the case but something more important, the satisfaction of knowing I had stood up for what was right. The story of the HOA daycare became part of my identity, whether I liked it or not. Friends introduced me to new people with "This is Zach. He is the guy who sued his HOA." Colleagues referenced it when discussing standing up to unreasonable clients or business partners. It became a shorthand for refusing to be pushed around. I did not mind, mostly. It was better than being known for something terrible or embarrassing. Being the guy who fought back against HOA overreach was a reputation I could live with. Natasha and I got engaged 2 years after we started dating. We had a small ceremony in my backyard, which felt appropriate given everything the house and I had been through together. The neighborhood threw us a party, organized by the HOA, which would have been unthinkable during Patricia's time. It was a beautiful afternoon, with friends, neighbors and family celebrating something joyful in a space that had once been the center of so much conflict. Standing in my backyard, looking at the people I cared about gathered in my home, I felt a profound sense of peace. The battle was over. Justice had been served. Life had moved on, and I had not just survived the experience but emerged stronger and more connected to my community than ever before. The house that Patricia and Brenda had tried to steal from me was still mine. The property rights they had tried to violate were intact and protected by new laws. The money they had made from illegally using my home had been returned to me with substantial additional damages. And the power they had abused had been stripped away and redistributed to a more responsible leadership. In the end, that was what mattered. Not revenge, though the large judgment certainly felt good. Not punishment, though both Patricia and Brenda had faced serious consequences. What mattered was that the system had worked, justice had been served, and the next person facing a similar situation would have better protections and legal precedents to rely on. As I stood there with Natasha, celebrating our future in the home I had fought so hard to protect, I thought about how strange life could be. A business trip to Phoenix had turned into a nightmare scenario, which had turned into a lengthy legal battle, which had turned into a landmark case and legislative change, which had turned into a better community and a stronger version of myself. If someone had told me when I first bought the house that I would eventually sue the HOA for $250,000 and win, I would have thought they were crazy. But life surprises you, for better and worse. The key is how you respond when those surprises come. I chose to fight, and that made all the difference. Not because fighting is always the right answer, but because in this particular situation, against these particular people, with these particular stakes, standing up was the only option that preserved my dignity and my rights. The last time I saw anything related to Brenda was a few years later when I happened to see her in a grocery store in Phoenix. She was wearing a store uniform, scanning items at a checkout lane. Our eyes met for a brief moment. She looked tired and older than her years. I felt nothing, no anger, no satisfaction, no pity. Just a vague acknowledgement that we had both been through something significant and had emerged on opposite sides of justice. I did not approach her or say anything. There was nothing left to say. The courts had spoken. The judgment had been paid. The chapter was closed. Patricia I never saw again, which was fine by me. I heard rumors occasionally about her trying to get involved in HOA governance in her new community in Tucson, but nothing came of it. Apparently, word had spread about what she had done in Scottsdale, and no one wanted her anywhere near a position of authority. The daycare parents moved on with their lives, finding other childcare solutions. A few ended up using a legitimate, licensed daycare that opened in Scottsdale not far from our neighborhood. Jennifer, the woman who had brought me the apple pie, occasionally sent me Christmas cards with updates about her family. It was a small kindness that I appreciated. My business continued to grow, and Natasha's architecture firm thrived as well. We bought a second property together, a small vacation home in Sedona, carefully ensuring it was not part of any HOA. We joked about my HOA trauma, but there was truth beneath the humor. Once you have been through something like that, you are more careful about where you put yourself at risk. The Quinn Law, as it became known in HOA circles, had a real impact. Several other homeowners in Arizona successfully used it to fight back against HOA overreach. One case involved an HOA trying to force a homeowner to remove a solar panel installation. Another involved an attempt to charge special assessments without proper notice. In each case, the stronger protections and clearer procedures created by the law helped homeowners defend their rights. I stayed in touch with some of the advocates I had met during my case, and we formed a loose network of people who had fought HOA battles and won. We shared information, recommended attorneys, and supported each other when new cases came up. It became a small but passionate community of people committed to the idea that homeownership meant something, and that boards and associations existed to serve homeowners, not rule over them. 5 years after the incident, I was invited back to that HOA governance conference to give an update on how things had changed. The audience was even larger this time, and people were eager to hear how my story had evolved. The lawsuit was the beginning, not the end, I told them. Winning a judgment feels great, but the real victory is in what comes after. For me, that meant staying involved in my HOA, working to create better systems, and making sure what happened to me could not happen to someone else. It meant turning anger and violation into constructive change. Someone asked if I would do it all again, knowing how much time and stress it would cost. Absolutely, I said without hesitation. Property rights matter. Standing up to abuse matters. Holding people accountable matters. Was it hard? Yes. Was it worth it? Without question. The conference organizer later told me that my session had the highest attendance and best evaluations of the entire event. People were hungry for stories of regular individuals standing up to institutional power and winning. In a world that often felt overwhelming and unjust, my case offered hope that fighting back could actually work. As I write this now, 7 years after walking into my house to find it had been turned into an illegal daycare, I can say with certainty that pursuing justice was the right choice. The road was long and difficult, but the destination was worth it. I protected my home, held wrongdoers accountable, helped change the law, and rebuilt my community into something better. Brenda Morrison never fully paid off her portion of the judgment, but the bankruptcy court and payment plans recovered most of it. She lives a quiet, diminished life now, the consequences of her choices following her long after her prison sentence ended. Patricia Schneider faded into obscurity, her name becoming synonymous in local HOA circles with corruption and abuse of power. My house stands as it always has, my property, my home, my sanctuary. The living room where 12 toddlers once ran around is now a comfortable space where Natasha and I watch movies and entertain friends. The kitchen where Brenda prepared snacks for her illegal daycare is now where we cook meals and share conversations. Every room has been reclaimed, renovated, and made completely mine again. The security cameras remain, but I check them less frequently now. The fear and violation have faded, replaced by confidence and security. I know my rights. I know how to defend them. And I know that if anyone ever tried something like that again, I would be ready. That is the real legacy of the case. Not the money, though that was significant. Not the law change, though that helps others. The real legacy is the knowledge that I stood up when it mattered, fought back when it was hard, and won when victory seemed uncertain. That knowledge shapes how I move through the world now, giving me confidence in situations where I might once have backed down. Natasha says the experience made me more empathetic as well as more assertive. I understand now what it feels like to have your rights violated, your home invaded, your sense of security shattered. That understanding makes me more patient with clients and friends who are going through their own battles, more willing to offer support and advice, more committed to helping others find their own victories. The HOA remains well-run and drama-free. The Architectural Review Committee I serve on handles dozens of requests each year, and we pride ourselves on being fair, efficient, and reasonable. When homeowners compliment us on how easy the process was or how quickly we responded, I feel a quiet satisfaction. This is what the HOA should have been all along. Sometimes I drive through the neighborhood and think about how different things could have been. If I had arrived home a day later, would Brenda have removed evidence? If I had been less willing to fight, would Patricia have gotten away with it? If the HOA had had better leadership from the start, would any of this have happened at all? But those are hypotheticals. What actually happened is that I came home, found an illegal daycare in my house, fought back through the legal system, won a significant judgment, helped change the law and rebuilt my life and my community. That is the reality, and it is a reality I am proud of. The story ends not with dramatic confrontation or sudden revelation, but with something quieter and more meaningful. A life well lived in a home well protected in a community well served. Justice was done, lessons were learned, and the world became a slightly better place because one person refused to accept being victimized and pushed back with everything he had. That is enough. That is more than enough. That is everything.